I'd like to do what everyone else has done and really thank the organizers of this conference for having invited me. When I heard that I'd had my paper accepted, I immediately enrolled for some elocution and pronunciation lessons, and after hours I managed to lose my Australian accent and haven't quite mastered the American one, but I got close with this Canadian accent, so I'm doing the best I can. Now look, last session, a great day. So in order to try to keep you awake, I'm going to be moderately provocative. In fact, I'm going to be really provocative. Most of you are Americans. I'm going to show you a copy of a good Constitution. Actually, it's a great Constitution in the sense Will meant it. This is the Australian Constitution, so you can keep your eyes on that if you want. Now, I'm going to argue that that's the best Constitution in the world, actually, and that matters because really what I'm trying to argue is that there's some reason why you should give a hoot about Australia. And I start with two preliminary things. Firstly, that there actually exists the odd originalist top judge in Australia. And by that I mean self-declared originalists, not ones you can intuit some sort of originalist reasoning. And the second reason, preliminary reason why you ought to care about Australia, and I say this as a Canadian, is that Australia has a great constitution, but it's basically a copy of the American Constitution. I'll tell you why in a second. It's certainly the most successful copy of the American Constitution. We can argue about whether maybe the Philippines or something has more of a copy, but the Australians have a really well-working constitution, and the founders knew their American Constitution. So in the late 19th century, they had the models from around the world in front of them, and almost every time it came to a big decision, they opted for the American model. So bicameralism, it looks like the US. Each state gets the same number of senators. It's an elected upper house. It can even block money bills. Believe me, in the Westminster system, that's very unusual. Canada, to this day, doesn't even have an elected upper house. They never do anything except get paid a full salary. So they look even worse than the UK with their still partly a hereditary upper house. And New Zealand, of course, has no upper house. They opted for the American one. So strong bicameralism. Of course, in the Westminster system, we don't have puffed up senators running around thinking they're the bee's knees. In the Westminster system, our key house is the lower house. So for any of you who were disappointed by the recent election here in the US, had it been taken place under the Australian model, you would have Prime Minister Boehner, and you can take that for whatever it's worth. So our upper house is strong in Australia, but the Senate is seen as the lesser house because, of course, you have to choose your Prime Minister and Treasurer from the lower house by convention. So they copied the American model, but they made it better because they introduced Section 57, which is in the very rare instances where the houses can't agree, they built in a dispute resolution mechanism. Won't go into it, but it's called the double dissolution. It hardly ever happens, but when it does, they've set it up so there's twice as many members of the House, where each, they divide the country by population, equal-sized districts, and the Senate, which is highly, Tasmania gets 12, and New South Wales gets 12, and they've set it up so there's twice as many members of the House as the Senate, so when you have a double dissolution after not being able to agree it's complicated, you end up in a joint sitting, and there's twice as many members of the House. The more Democratic chamber will win. 99% of the time, it's conceivable that they wouldn't. Federalism, they copied the US. They had the Canadian model in front of them. They hated it. So we have an enumerated list of powers for the center, and everything else goes to the states. Well, they just copied that from here. And that sort of federalism means that the states pick their own top judges, unlike Canada, where the center picks everything. So I remember reading Tushnet once, or somebody talking about how apolitical Canadian judges were, which is ridiculous. Here's what happens in Canada. We had the same left-of-center party in power for basically 40 years, and they pick not only federal judges, Supreme Court judges, they pick all the top judges in all the provinces. So of course they look apolitical because they've all been appointed by the same party. Australia, the states pick the judges for the state courts, and the federal court is a really lesser court, really. So we've got American federalism. We've got no national criminal law. We're like the US, unlike Canada. They even copied the US in terms of a capital city. Canberra, that's a district, doesn't really get, I mean, you can only understand Canberra in terms of Washington, D.C., and I was struggling to come up with some historical way to connect the U.S. and Australia for the historical papers that were very interesting, and this is about the best I could come up with. In 1788, James Cook discovered Australia. He discovered New Zealand. He beat the French to Australia by about 2 weeks, apparently. In the late 1750s, this young navigator took General Wolfe up the St. Lawrence, and then considered to be unnavigable. Came around behind, went up to the Fields of Abraham, knocked off General Montcalm, and took out the entire French presence in North America. That was James Cook, the first great thing he did. And I think it's pretty clear that if the British hadn't knocked the French out of North America, there wouldn't have been a war of independence. No way they would have chanced it, I don't think. But anyway, I could be wrong. So that's the same guy. That's my connection. That's tenuous, I know. Here's the two things that Australia did not do. Having looked at the American Constitution, studied it, they knew it. They didn't like the amending formula, 2/3 of both houses and 3/4 of the states. And I always hear supermajoritarianism, but it's not really. It's a supermajoritarianism of politicians and legislators. The Australian founders went for the Swiss model. We have direct constitutional amendments require referendum, 50% of the people in the country and 50% of the people in a majority of states. There's 6 states, you need 4 states. Been 44 referenda to change the Constitution, 38 have failed. Of those 38 that failed, I think all but 5 failed because you couldn't get half the country to agree. A few years back, there was a referendum to move to a republic. All of the parties were in favor. On any understanding of constitutional amendment that only involved politicians, it would have gone through easily. It got slaughtered. It got slaughtered in every state, and they made the right call in my view. But so they have a different amending formula, a very Swiss one they copied from the Swiss. And the last thing is they spent an inordinate amount of time looking at your Bill of Rights, and they just rejected it. They debated it. They thought about it. This was the sort of first version of Madison. They figured all the other checks would be better. I agree with them. I don't like Bills of Rights, but it's going to work into the paper later. So that's the really quick version of Australia. You will recognize big chunks of it. The last 2 parts of the paper, after the sort of introductory preliminary points of why you might even consider Australia as American originalist, came in 2 parts. The second part, which I'll just quickly allude to as I go through 3 egregious High Court of Australia decisions. The top court in Australia is called the High Court. These are decisions where the majority judges employ blatantly living constitutional approaches, and the minority give good, solid originalism dissents. And you get to see the extent to which you can just make up anything as a non-originalist. And I picked these 3 cases just because I like the results in a first-order preference or value thing. If I were legislating, I'd probably go with the judges. They're ridiculous interpretive claims about what the Constitution says. So, you know, the real test of your interpretive mettle is whether it takes you to results you don't like. And I've never actually, I know he just died a couple days ago, but I've never actually read Dworkin and ever give an example of a case that's rightly decided that he doesn't like the result of, and I think that's a problem for an interpretive theory. So the 3 I pick, I think, are terrible interpretive examples of judgecraft, but I quite like the results in the abstract, so I picked those. But as enjoyable as picking apart the reasoning of top judges may or may not be, I'll just leave that for question time. The part of the paper after the preliminary part, before I get to that, is just setting up the argument. Again, going back to why you might care about what's happening in Australia. And so I run through the sort of philosophical distinctions. And the first one is you might be an originalist because you're a conceptual originalist, or you might be an originalist because you care about where it's taking you, as it were, because you care about its instrumental benefits. And I have to confess that growing up in Canada and going to Canadian law school, I didn't even know what originalism was. So when I moved to Australia eventually, having spent a long time in New Zealand, I ran into the sort of Jeff Goldsworthy version of originalism, which is a form of original public meaning. I quite liked it. But I have to confess I've moved over to the sort of Larry Alexander, Rick Kay, Stanley Fish and occasionally Stephen on Every Second Day version of Original Intentions, Originalism, and I know that it's fairly, but I mean, I've moved over that. But I guess the point there is that you can be a conceptual originalist, this is just what meaning is, or you can be an originalist who says, I like originalism because of what it delivers, and they're not mutually exclusive, of course. In fact, I'm probably both. So that's the first thing, I think. You're not probably going to care too much about Australia if you say this is just what originalism is. But if you're okay, I've got to be quick. So the last two distinctions, and we'll throw it up into questions. I think the sort of normative originalism that matters to me is what you guys have been calling popular sovereignty, is the sort of more scope for democratic decision making and more constrained judges, because if you buy it, and I do, that the search for historical truth is more constraining than I've looked inside myself and discovered what the right moral answer is, and I can assure you all that I feel constrained approach to interpretation, then that has good consequences too. So I just run through that, and then at the end I just conclude that the sort of Scalia desire to have constrained judges in the big ticket Bill of Rights cases might be pretty depressed if you look at Australia, where there's no moral flabbiness, it's not a morally pregnant constitution really, certainly not compared to the US. And even there, the top judges just do remarkable things. So when it came to something like a Bill of Rights, I don't know how confident we originalists can be that all these benefits that we hope originalism will deliver will actually deliver, assuming you're a popular sovereignty guy like me, in which case, if you're going to be an optimist, you have to be one because you're flying in the face of the facts, which I'm prepared to do, I suppose, but it does seem a bit ironic. So that was it.